Hello, and welcome to Nixon Peabody's What's New virtual on demand series. I'm John Eden, an attorney in the San Francisco office. I'm here with Richard Shamos out of our Los Angeles office. Today, we will give you a glimpse of what's new as venture backed companies and VC firms seek to balance risk and opportunity in a highly dynamic, ever evolving market. We're going to focus on continuation fund transactions in this discussion. Richard, how are you doing today?
Hi, John. Doing very well, thanks. And excited to talk about what is a very interesting trend, I think, within a kind of hybrid space that covers both venture capital and private equity and the investment funds space. So maybe to kind of set the stage, we'll answer the question or pose the question, well, what exactly is a continuation fund and what type of transaction are we talking about? So briefly, a continuation fund transaction is effectively where a fund that holds a particular asset, generally a private asset, sells that asset to an affiliated fund. So, in other words, you have a manager who manages one pooled vehicle, selling it to another pooled vehicle that they also control. And these situations can arise in a variety of contexts. But generally, it's closely related to the life cycle of a private equity fund and the life cycle of an investment. Within the venture capital space, we might see these transactions for a number of reasons. And John, maybe will be helpful is for you to talk a little bit about the life cycle of a venture capital investment or a private equity investment and how that aligns with different types of investors we see in the space.
Yeah, I'd be happy to do that. So, within the venture capital world, especially when you're thinking about tier one and tier two venture capital firms, they try to get into big ideas and big opportunities as early as they can. And they stay in for quite some time. And the reason they do that is that, relative to other types of investors, they're not really cash constrained and they're really willing to embrace a certain amount of risk. One of the things that we're seeing in the venture capital space is new types of investors who are more capital constrained, but who still want exposure to, great companies about to go public. And it's at that kind of posture that you get these continuation fund transactions.
So that's a really interesting point, John. And maybe I'll tee up, one or two examples that, we've certainly encountered ourselves. Uh, Often in the life cycle of a venture capital investment, there will be a number of rounds of investments, so various series of rounds. And for many companies, their ultimate goal is to enter into an IPO. I expect along the way, we see various types of investors in those particular series and rounds. And often investors want to exit. Now, John, I wonder if you could just, what kind of investors do we see, typically coming into an IPO or pre-IPO type of security or type of situation versus an early venture capital investor? And, how do their risk profiles and philosophies differ?
That's a great question. So these investors who come in immediately before an IPO and want to do a continuation fund transaction, they have less capital. So they're relative to a tier one or a tier two VC, they're capital constrained, but they do have significant capital to deploy. And what they want is they want to come in at a point where they can get exposure to, a pre-IPO security that they know is going to become an IPO security. So they do, they're looking for really hot companies in really important spaces, but they don't have the capital or the exposure tolerance to stay in for 10 years or 8 years or what you typically see with a tier one or a tier two. So they come in at this great moment where, in terms of whether the security is going to be a public security, that's been completely de-risked, right? The only question remains, and this is where the risk lies, is, how's the company going to do in its first year or two? So for the first 4 or 8 quarters post IPO, how's that company going to do? The investors that you and I are talking about and the ones that we interact with in these transactions, they're willing to try and model that risk because they think the bigger risk, which is whether or not, a company will go to the dead pool or not, has already been taken care of because they're coming in, at this moment where there's at least certainty around whether there will be an IPO.
That's, I think, an excellent explanation of the circumstances we see, John, and a very good segue as well into maybe some of the funds issues that are raised by this circumstance. And so to recap, effectively, we've got a circumstance where investors have a particular risk preference and want to invest in an asset while other investors are looking to exit. And a question that might come up then is, well, why not just sell the asset? And the reason we see funds not just outright selling these assets is either, one, some of the existing investors in that asset might actually be okay with holding that asset for a longer period and entering that new risk phase. You certainly see that from one series to the next. And you may see that as well from a venture capital investment into a pre-IPO and IPO phase. A second reason that we might see a fund transaction or an affiliated transaction instead of an outright sale to third parties is often the manager is very involved in the underlying companies. Private equity and venture capital investors bring specific expertise to the industries in which they invest. So many times the new investors want that manager to stick around. Right? They may see the value that they've added over time and may want them to remain involved. And that has specific repercussions for the type of documentation. And John, maybe I'd ask you to touch a bit about the transaction documentation that we normally see in this type of sale, and then we can talk about some of the funds documentation as well that accompanies it.
Yeah, absolutely. So, before you actually move forward on a transaction like this, you really need the original fund, the governance of the original fund to okay the transaction. Then you also need consent of the company, and those are two prerequisites. And I just wanted to touch on those briefly. But once you have those and you start moving forward, these transactions are facilitated by a purchase agreement. And the purchase agreement is among the principal fund, the continuation fund, and the underlying issuer of the securities, which is the company. And so these purchase agreements have many different moving parts, and it's important to have a plan around how you're going to manage those moving parts before you get into them. So, one of the things that you do, just to give an example, is you make sure that you understand the governing series of preferred stock purchase agreements that govern the relevant securities in question. So once you understand those, those basic rights and privileges will play a role in what you need to do in order to get the company's consent in this purchase agreement.
I think that's a great segue, John, and I appreciate as well you're touching on some of these conflicts issues and the consent of investors required, and that it in fact is a hallmark of these continuation fund transactions. Even though we have a purchase agreement, or I should say it's unique that we have a purchase agreement, right? Because you have two funds that are managed by the same person selling an asset, right? So why do you need a purchase agreement when it's really assets that are affiliates? They're controlled by the same entity. And the reason, obviously, for that is that the underlying investors are different. And those investors are ultimately the beneficiaries of the investment, and they're the persons that the manager serves. So the manager of the selling fund has to go and get consent of its existing investors to engage in this conflict transaction with its other affiliated fund. And generally, the investors in the new fund want to have some role in overseeing the rights and privileges in connection with the sale. They don't want to end up stuck with a bad asset and have no control rights in this new fund. So, this continuation fund transaction kind of takes on the elements of not just an affiliated transfer, but more so a third-party transaction. And that would be the reason for the purchase agreement. One other item that I just want to touch on related to this transfer, and it's a point I raised earlier, which is sometimes you have investors who want to stay in this particular asset and they kind of roll their interest in the selling fund into the new fund. Um, those types of transactions can add a really interesting wrinkle to a continuation fund transaction, and often some added complexity as far as negotiations with investors. One big issue that any manager in the space should be aware of is tax, right? So anybody who has invested in an asset and remains invested in some type of continuation vehicle is likely going to want to preserve their tax basis. Closing out an investment in a private equity vehicle and then restarting it in a new one involves a number of mechanical issues in addition to the tax issues that have to be carefully aligned. And this is an area where Nixon Peabody has a lot of experience and expertise. And so we'd certainly recommend anybody looking to do one of these transactions to seek counsel, not just on the transactional components, but also on taxation.
Richard, one more question that the audience might be interested in. When you so people, this is especially helpful. This would be especially helpful to people who work in pure M&A or in venture capital on the company side purely. Tell us about the timeline of these transactions. How long do these take typically?
Well, the timeline on the transaction, can vary, and it's gonna depend on the complexity and the different components, right? If you have existing investors coming into the new deal, if you've got a large asset that requires intense negotiation around the purchase agreement. So, we've seen these transactions move at anywhere from a month or 6 weeks up to 3 months. So there are a number of components, not just the deal components to get in place, but also the funds and the fund mechanics and the fund documentation. So, that timeline can vary as well.
Perfect, perfect. Thanks for that. I think that's helpful to some of these folks who haven't seen one of these up close and personal.
Yeah, absolutely. As with any deal, we certainly have timelines in mind, and have a team of attorneys who will certainly do everything they can to make sure that a deal can close and that everyone is successful and happy with the end result. With that, I hope that you found this discussion helpful. Should you have further questions, please feel free to reach out to myself, Richard Shamos, or my colleague John Eden, and we'd be happy to discuss with you. And stay tuned for more from the What's New series here at Nixon Peabody, including very interesting talks from our corporate teams, labor and employment, and many others. So thank you, and have a great day.